enjoyed our conversation a couple of days ago. It was very helpful. And I want to pick up, and I think we can do it quickly, on some of the questions I asked you with respect to gaps in FISA protection for law-abiding Americans. That's my concern. So current FISA law prohibits the intelligence community from collecting GPS information on Americans overseas without a warrant. Is there any reason why that protection should not be extended to Americans in the United States?
No, Senator. As we talked about when we spoke, if, for example, under 704 of FISA, if that authority requires a warrant under 704 to obtain geolocation data for an American abroad, then if the government is also trying to compel a company to produce geolocation information in the United States, then that should also require a warrant, in my view.
So, following up on that, current FISA law would require a warrant to search an American's apartment overseas. But if that American visits the United States, it's not clear that those provisions apply. Is there any reason why a warrant shouldn't be required to search that American's apartment overseas, regardless of whether where that American is at that moment?
Yeah, so I agree with that as well. That is a gap, I think, in the law. We sometimes refer to that as like the vacation home gap. But yes, I don't have any objection in principle to requiring a warrant to search an American's home overseas for foreign intelligence purposes.
We're making good progress. Let me now go to this question of secret law. And my colleagues here have heard me describe this on a number of occasions. But, I feel very strongly that sources and methods have got to be secret. And that has got to be a sacrosanct principle in the intelligence community. I think the laws have got to be public. And that means basically you ought to be able to sit in a coffee shop somewhere and read a public law, because that's what our system depends on, is people having knowledge of public laws. And as you know, we had something that we Jewish people call a kerfuffle with respect to some of the definitions in 702, because on its face, it could allow the government to force just about any American with access to a Wi-Fi or a cable to participate in warrantless surveillance. That, to me, is what it said on its face. Now, to me, this isn't how legislation should be written, and it adds to distrust. So my question here is, would you agree that the public has a significant interest in knowing the boundaries, and I choose that word specifically, of these authorities?
Yeah, so I couldn't agree with you more. I think in a democracy, it's important that our laws be transparent and public to the maximum extent possible. In the intelligence area, as you know, that can pose challenges because the activities are secret. And so have the legal basis for those activities, we want that to be public to the maximum extent that we can, but there can be challenges in doing so in order to protect the activities that we need to keep secret. So I think with respect to the specific issue that you're referring to, which is the revision in the most recent reform to the definition of electronic communications service provider, I think what we've tried to do, working with the committee and working with the chairman, is to make as much information as possible public about what that new definition is intended to mean. It's a narrow change in the law to really address a change in how the communications architecture has evolved since ECBA was adopted in the 90s, and it was in response to a very specific FISA court decision that said that a particular type of company was beyond the jurisdiction of the law. And so we've done as much as possible, including working with the chairman, to make clear that it was intended to be a very narrow technical fix. And my understanding is that in the draft Intel Authorization Act, we're going to go another step farther to try to link that definition to that court decision in a way that will try to provide as much as we can, possibly while protecting the sources and methods, as you said, Senator, that we need to protect.
Let me get to my last question,
Sure.
Because I work closely with the chairman and the vice chairman, and I think we made some progress on the definition.
Yes.
But this is still, as you and I talk, this is a balancing act. So here's my question. Under the executive order that controls classification, the DNI is supposed to weigh whatever sensitivities might exist against the public interest in the information. Now, if you're confirmed, you're going to be advising the DNI. And I would like to know whether you believe that when it comes to public law, those specific words, the public has got a strong interest in knowing what it means.
I absolutely think the public has a strong interest. I know the DNI also believes in transparency. So I certainly would advise her on that. But it can be challenging sometimes, given the interest in protecting our equities.
There's no question it's going to be challenging. That's
Yeah.
why I thought you were a smart guy at the beginning, and I appreciated the questions. I just want to have somebody in that room
Yeah.
who's going to understand the difference, and I think you do, and this is going to be an ongoing kind of process between, sources and methods, got to be secret, and public law, so people can sit in a coffee shop and figure out what in the world's going on back here.
I get it.
Thank
I understand.
You. Thank you, Mr. Chairman.
Thank you, Senator Wyden. Senator Risch agreed to pass for the time and move to Senator Cornyn.
Congratulations, Mr. Wigman, on your nomination.